Many people will give you advice if you lose a spouse. And one of the pieces of advice is don't do anything for a year. And I think I get it on the human side, but there are some really important things that are financial and estate matters that really you have to. It's like putting your oxygen mask on in the airplane when it comes down. You need to put that on because these are really important issues, and these are time sensitive issues. So if this is something you're going through now, my condolences. And there's stuff you need to do, and there's no other way to say it, but you do need to do these things, and you just got to get it done. This is something near and dear to my heart. I've been married a long time, and many of my clients have been married a long time too. So when this happens, right, as we think about this ending of the marriage by death, it's really a big deal, and it's something that we help our clients out with a lot in our law firm. So these are people who were married and have the marriage has ended because the spouse has passed away. Now there is a very much a human side. And I would say one of the great things about choosing law as a profession and doing this type of work is we get to do work that matters, right? Especially, you meet with someone who's lost the love of their life that might have been married 50, 60, 70, 80 years, and they lose a spouse. And really, it's a total shock, right? I can't tell you how many times I've met with both women and men, and their spouse died suddenly. And it takes a while for your body and your brain to just absorb the shock. Okay, it's a huge, it's a huge thing to go through, right? A lot of people have told me that, my body aches and I feel numb at the same time. Like, how is that even possible? I can't think straight. I mean, I can't tell you how many times people say to me, I lost my spouse. It's been 9 months. I still can't think straight. Right. I don't understand why I can't do it. And then a lot of times they just say, I just want to be by myself. I just want to be at home, and there's stuff you need to do. And there's no other way to say it, but you do need to do these things, and you just got to get it done. Really important to assess your cash flow needs and income sources, because that can change when a spouse passes away, especially if you're receiving a pension. Many of these pensions get cut down to 55%. So it's something to pay attention to. A lot of Social Security is most of the time is reduced on, at least on some level. And there are some estate issues, some tax and estate issues with hard deadlines. And the whole point of doing this is so you can have peace of mind. I would say that this shock is measured in months, typically more than 12. And when we meet with people about a year later, a year and a half later, for most people, I don't want to say it gets better, but this sort of shock and numbness starts waning. And then you renew you, and it's on your own timeline in your own way. And you just got to put one foot in front of the other and keep moving. So, what should you do? What are the big to-dos from sort of the estate side, right? So, do you lose a spouse? What do? You need to collect all the estate documents and the asset information. It's very important to have this information. This is highly relevant information, and it drives much of the decision-making from the lawyer's standpoint and also your standpoint. And you do have to start making decisions, right? People will be contacting you. Are you going to make this election or that election? What are you going to do with the IRA or the 401k? These are things that you've got to deal with. A savvy lawyer, and what I mean by that is there are different kinds of lawyers. And if you're watching this and you go, well, I think lawyers are I don't know, they're different kinds of lawyers. A lot of people have no idea that there are a whole bunch of subspecialties. Now, lawyers who regularly practice in this area comprise about 7% of all lawyers. So it's a really small field, right? This is not, there aren't a lot of lawyers who really know what they're doing in this space, but you really need someone who knows what they're doing, because the lawyer can identify essentially what's missing. Now, that's what you need with an expert, is you look at a bunch of documents and the expert says, okay, you've got 9 things, there's this 10th thing that's missing. Where's that? And that's really the value that fundamentally a lawyer brings to what's going on, is making sure that you pay attention to what's missing. So the lawyer should review these documents, sort of the estate documents and the assets in detail. Now, there are many deadlines, and I'm just going to kind of go through these quickly. In California, you have to lodge the will within 60 days, which means deposit it in the county court of residence of a person who passes away. That has to happen within 30 days. There's a requirement to notify people when a trust becomes irrevocable. Now, not all trusts become irrevocable, but many do, okay? When a trust becomes irrevocable by death, you have to notify everyone who's named in the trust and everyone who would inherit if there were no trust. So not only do you have to name all the people who are in the trust and any prior amendments, right? But you also have to name all the people who would inherit if there were no trust. Now, how do you know that? Like, this is a rule. And by the way, this is typically not put inside of the trust. And this is the point of, you have to follow the terms of the trust and the law, because this typically is not in the trust. You have to do that within 60 days. And, you know, if you're a beneficiary, if you're someone who's inheriting and you've seen this and you're like, well, I never got that and it's been 2 years, that trustee's not doing their job. Okay. You have to notify the county assessor within 60 days when there is a change in ownership. And we'll cover here a little bit later. Typically, and typically, transfers between spouses are not changes in ownership. If you have a trust in the middle, sometimes it can be a change of ownership, and we'll talk about that. You also have to notify the California Department of Healthcare Services within 90 days if a person has received any Medi-Cal benefits. So that's something you've got to notify. If no copy of the trust is served, so not only do you have to notify the people who are named in the trust and the people who aren't named in the trust, you have to notify them that a person's passed away. This trust is irrevocable. They have 4 months or 120 days to challenge the trust. If you don't give them a copy of the trust when you send that notification out, they have, within that 120-day period, they can ask for the documents on the 119th day, and they get an extra 60 days to challenge the trust. So this is about closing out. This is about shortening the time period to challenge a trust to 4 months. And again, how do you know who to notify, right? Do you have all these addresses? This is overwhelming. You just lost your spouse and now you've got to do something within 4 months. I mean, give me a break. This is ridiculous. But again, if you don't serve a copy, and I'm not suggesting that you should serve a copy of the trust with the notice, but if you don't, there's another time period involved. The death of real property form must be filed with the assessor within 150 days of the date of death. So here's, the assessor has to be notified within 60 days, and there's a death of real property owner that has to be notified as well, and that's within 150 days. So if you're required by the trust to perform an accounting within 60, you have to provide that within 60 days of a request, but some people can only request once every 6 months. So there's lawfully people can get 2 accountings per year, and the requirement is to deliver an accounting within 60 days of request. And the creditors of the deceased spouse, this is if the deceased spouse owed people money, they have 1 year under Code of Civil Procedure, section 366.1 and 366.2. Sometimes it's longer. So this cuts almost all the statutes of limitation down to 1 year, but there's some exceptions that are kind of not so minor, but for most people don't apply. The really big to do, by the way, is looking at filing the portability 706. This is the federal estate tax return that is due within 9 months. So that's yet another time period. And that's where you claim your extra almost $13 million coupon to leave. So if you're a surviving spouse, that's almost 26 million by filing this form 706. And again, your exemption or your ability to leave property when you die could be cut down quite a bit in the future. We just don't know. We don't know who the president's going to be. We don't know what Congress is going to do. You don't know what your assets are going to be. There's a lot of unknowns. But I would say consider hiring either a lawyer or a CPA who does these a lot. And I will say that, you know, the smaller CPA firms oftentimes don't have many clients die. Our firm, we handle a lot of trust administrations. We're doing these many times a week in our firm. Okay, so this is something that happens regularly. And I would say in a bigger CPA firm, that's probably handled regularly, but it's something where you want to have somebody who does this quite a bit because it is a little tricky. It's a little technical. And then there's this other bonus deadline. This Code of Civil Procedure section 366.1 and 366.2. It cuts the statute of limitations down to a year. So if there's a lawsuit out there that you're worried about as a surviving spouse, those are typically cut off after a year. And so your tax filing status, when you lose a spouse, you can qualify as a widower or a widow for the year of death plus 2 additional years. Now, this presents a really big tax opportunity, a tax planning opportunity, because you're effectively paying taxes at a lower rate during that year of death plus the 2 years. You're paying taxes at a significantly lower amount, right? And it gives you some tax planning options. So something really to think about. And again, this goes to, don't just bury your head in the sand for 3 years. If you've got some tax sensitive type assets, there's a lot that you can do. So one thing to remember is all property that's community property gets an adjusted cost basis at death. So the surviving spouse can sell that property and mitigate some capital gains taxes. On the flip side, if assets have gone down, if you paid $1 million for something and it's worth 500, your new basis is 500. So, you're going to miss out on that loss potentially. And that's really relevant when it comes to marketable securities, individual stocks. You really want to make sure that you meet with your financial, lawyer, CPA, financial advisor to get those bases, right? All those cost bases adjusted on your individual stock return. So a lot to do. A lot of accounting work, a lot of background work. Some people say, oh, I can do this. I want to do this. I want to be involved. Other people the vast majority of people are like, look, I know this needs to get done and I'm going to get the right people to do this. I would say that what I've noticed about wealthy people is they are not shy to hire professionals, and because they see there's value there, and there's only so much time that you've got left. And do you really want to spend it, so that your kids inherit a little bit more money? I don't know. That's your call if you're the one making the decisions. So remember, the estate tax changes in 2026. The ability to leave $13 million that we have today in 2023 is going to get cut in half in 2026 when those estate tax laws sunset. So you can leave about 26 million tax-free if you're married. That's going to be 13 million tax-free in 2026. So if you have assets over 10 million and you're married, you probably should pay attention to this. So property taxation when a spouse dies, if all real property, and that's what lawyers call real estate is real property. If all real property passes to a surviving spouse, there's no change in ownership by statute, so there's no reassessment. If any property passes to someone other than a spouse, it may be reassessed, and there's a few exceptions here, but it's something to be mindful of, because if you don't timely get these notifications into the assessor, then you're subject to penalties, and that's up to 8 years retrospectively. So these can be pretty significant penalties if you don't do anything for 10 years, right? And remember, the parent-to-child reassessment exclusion basically is gone. It's very throttled way back just for the family home and the family farm. There are some exceptions here for, co-tenancy. If 2 people occupy the home as their primary residence and somebody inherits it. Joint tenancy, if somebody acquires a property, adds someone as joint tenants, and that person they've added dies, there's no reassessment. And then LLCs and partnerships, that gets really, really complex really quick. We cover this in other webinars. I would just say, if you're going to buy a piece of property, you probably don't want to do it with a corporation. And I put corporations on there because that's typically legacy type structures. That's before even like LLCs existed. And really the modern way to do it is using an LLC. But here's kind of a red flag. If the property passes in a trust or otherwise to a spouse and the kids, the entire property may get reassessed. Okay, so this is really important. Pay attention to your estate plan. There used to be a parent-to-child reassessment exclusion, and that was a great thing. And so this was not as much of an issue. But now, since the 2020 election, it's become more of an issue. So if it's been a while, if you have not looked at your estate plan or not had a lawyer look at it since before 2021, you might want to take a look at that, because there are some rather technical terms that can be in a trust that result in reassessment when one spouse passes away. So you really want to pay close attention to that. And I would recommend you take a look at your estate plan if it's been more than a couple of years. So income taxation when a When a spouse passes away, in the year of death, you file as a widow or a widower, which is kind of like married filing jointly. And after the year of death, you've got 2 more years, as we discussed, and then you become a single filer. So this really gives you a really unique opportunity. Is you may find that when your spouse passes away, in those years where you have 3 tax years, you may want to look at a strategic Roth conversion. And that's where you say, hey, I've got a lot of traditional IRAs or 401ks. You got $3 million in IRAs. And as you start taking that money out, that's taxable as income, the government lets you convert that to a Roth IRA. So you do not have to take minimum distributions, right, that you otherwise have to take with an IRA. And if you do take them, then there's no income tax. And so I would say this is yet another reason to engage. If you have an IRA of any big size, I mean, I would say over 500,000, you really need people who really know what they're doing. A lot of people advise clients. Very few people know about Roth conversions and strategic Roth conversions. So I would say this is kind of the upper 5% of advisors across the board. And this can serve to reduce taxes following death, because the other thing to remember is if you have a really, like say you have a $10 million IRA and your kids inherit that, that's subject to a 40% death tax on the 10 million. And then the kids have to pay income tax when it comes out. So it's like, it's double taxed. So it's a really good idea to look at a Roth conversion, especially if you have a larger estate. And a downturn in the market, frankly, is a great time, as we've had a downturn picking up a little bit. We're in January of 2023, but it's a great time to look at a Roth conversion, because the value of the thing that you're converting is reduced. So, do you really need these darn appraisals? This is probably one of the most common questions. Jim, do I really need to get, I've got this apartment building. The appraisal is $2,000. Do I really need the appraisal? My answer is going to be yes, right? If I say no and you're audited and it causes a problem, why would I bring that on myself as a lawyer? Okay, so any reputable person who does this regularly is going to tell you, you got to spend the money and get the appraisal. Just do it. I mean, it's really pennies on the dollar. So, and this is really important. You get a new basis on depreciable assets. So you have that apartment building, you paid $100,000 for it. Now it's worth $1 million. It's fully depreciated. Now you have $1 million basis in the property, and you can depreciate the structures and the improvements on that property over time. So it really does pay to do that. And if it's an investment property, it's going to likely be a deductible expenditure. So very, very important. And it's also, you can couple something called cost segregation, which is really outside of the scope of what we're doing here, which changes the method of depreciation. So instead of depreciating a residential structure over 27.5 years, you might depreciate that over a much shorter period of time, maybe 7 years, and you can do these strategic Roth conversions and really take advantage of the basis that you get when a spouse passes away. And if this is totally over your head and you're like, Jim, what are you talking about? This is this is yet another reason why you need to engage professionals and a team approach, because for many of our clients, we are saving them. I met with the client yesterday. We're saving him $1 million in income tax, right? Now he makes a lot of money, but working with the CPA, we're saving him $1 million this year on income tax, because we're changing the way that property is depreciated. And that's $1 million that otherwise would have gone to the government in taxes. So very, very important. 754 election on a partnership. I would say I mentioned this on this webinar, and I've mentioned it on other webinars, because we had one instance where the accountant blew it and it cost the client about $2 million, okay, in taxes. So something to understand is when you own a partnership interest and that partner dies. And so let's say, Hal and Wanda own a partnership interest as community property, and Hal dies. Wanda gets a new basis in that portion of the partnership that she owns, right? On a high level. Partnership taxation is the most complex area of taxation, but you have to make this election on the 1065. This is the income tax return. So it's really important. If you're an investor in a partnership structure and somebody passes away, you need to let the managing partner or the general partner know what's going on. So it's very important. Hopefully they're asking you, but if they miss it, you miss it. So this is done on the income tax return. Very, very important. I think this is something that frequently is overlooked. This is very esoteric, very technical, but it's very important to understand. If you own a partnership interest, like an investment, and a spouse passes away, this is why you need to reach out to your team approach, your lawyer, your CPA, financial advisor, because again, if they're in this top 5% tier, they're going to be aware of this. Very important to understand. Adjusted cost basis, again, when one spouse passes away, if I die and my kids inherit property, they get that in adjusted cost basis. If a spouse dies and it's community property, so if I die on a community property asset and I have a community property asset, my wife inherits that, full adjusted cost basis, not automatic. Like the government's not doing this for you. And I get to tell you, I see a lot of clients coming in. Oh yeah, my spouse died 3 years ago, and I'm looking at their income tax return, and they haven't reset the basis on their rental properties. So that's really important, and I think a lot of people miss that, and that's why a good CPA is going to ask you that fill out that questionnaire when you go see the CPA. Have you lost a spouse this year? Well, the reason they're asking you is because it can benefit you tax wise, but yeah, you do have to get the property appraised, and you can typically sell it capital gains tax free, but this is not for B trusts. This is not for generation skipping and dynasty trusts. This is not for these specialty irrevocable trusts. If the property is already in the trust and somebody dies, then that's typically outside of somebody's estate. So you don't get this adjusted cost basis. Very important. And I want to finish up with when can you change an estate plan? So this is a question of, if somebody's passed away, you've lost a spouse, can you change who gets what? Right? That's a really big question. Now, you can change your last will and testament really anytime it's yours. Now, what does it cover? If all your assets are in a trust, then arguably that last will and testament in and of itself is not going to cover those. There's one exception we'll talk about in the next slide. But you can typically change a trust that is revocable, because revocable also means amendable. Now, I will tell you that the one big exception to changing your will or changing your revocable trust is if there's an agreement or a court order to leave somebody something. Okay, so this is very common in a divorce, where the property settlement agreement will say, well, you promised to leave me, if you died before 65, you promised to leave me $1 million. Okay, well, that's got to be in there. So in that sense, you can't really change that because it's a court order. But, again, we'll go back to Hal and Wanda. Hal dies and Wanda inherits everything from Hal in a survivor's trust. These survivors' trusts often, but not always. So if you're a lawyer watching this, you got to look at the whole trust when your client comes in. They are typically revocable and amendable. So she signs a new restatement of trust and leaves everything to Ned, her new beau. Remember Ned. So Wanda's leaving everything to Ned, and it's amendable. When can't you change your estate plan? Well, if it's an irrevocable trust. How do you know if it's an irrevocable trust? You're probably going to need to talk to a lawyer, okay? This is when you cannot change an estate plan. So you, acting on your own with an irrevocable trust, cannot change a trust that is irrevocable, because irrevocable trusts are unamendable. And a good way to remember this is irrevocable is a longer word than revocable, and unamendable is a longer word than amendable. So if you're kind of confused, the longer words mean that you can't change it. So Hal dies and Wanda inherits Hal's assets in a B trust. Now, a B trust is credit shelter trust, is a family trust. You might have heard these. These are just acronyms that lawyers. B stands for below ground trust. So this is the below ground spouse, who's Hal. It also stands for the buried spouse. So A is the above ground spouse and A is the alive spouse, which would be Wanda. So Hal's assets go into the B trust, which is the below ground spouse's trust for Wanda. And Wanda cannot leave all her assets to Ned, her new beau. But she can leave her assets, but not the B trust assets that Hal left in this trust. But if Wanda has something called a power of appointment, now this is, I would say, a very esoteric yet very powerful tool that is, many people don't understand enough about powers of appointment. And there's a lot written on the Internal Revenue Code about powers of appointment. Sometimes they're good, sometimes they're bad. But what a power of appointment means is that Wanda, if Hal put everything in this B trust, this irrevocable trust, Wanda cannot amend the trust. But if that trust says Wanda has the power to appoint trust property, the power to appoint, which is best understood as a power to disappoint, okay? If Wanda has this power to appoint property, then she can appoint it as provided in that trust. And it may say that Wanda can appoint the property to anyone she wants. So she could give it to Ned if she properly exercises the power of appointment, which can be exercised typically in 3 ways. One is by will. So when I said that will, typically you can't change the disposition of property, sometimes you can with the power of appointment if it's a testamentary power of appointment done by will. Then there is a power of appointment that can be done in a living trust, and also a power of appointment that can be exercised by a separate document. So powers of appointment, very important. So if you're a surviving spouse and you say, you know, my son-in-law is treating me like dirt and I want to disinherit him, you need to look at the documents. You need to have a lawyer look at those documents with you. And if you have a power of appointment, it may be possible to disinherit or to disappoint your stepson. Okay. Court intervention is another way to modify, not amend, but modify the terms of an irrevocable trust. If no one's dead, this is in the context of widows and widowers, so this doesn't really apply. If nobody's deceased, then you can sometimes modify a trust by agreement. But if one person's passed away, it does require court intervention under California law. And then there's the trust protector, and a trust protector we've covered in other webinars. Basically, a trust protector is a person who has power over the trust, but is not the trustee. So if the trust says, drive the car down Highway 99 from San Francisco to LA, and everyone goes, that's going to take 2 hours longer because the trust was written before Highway 5 was built, the trust protector can say, don't go down Highway 99, go down Highway 5. And that's kind of the things that a trust protector does. So a trust protector has power over the trust, but is not the trustee. A trustee must follow the terms of the trust as written. And sometimes those terms don't make sense. Well, that concludes our content. We do have offices in Northern and Southern California, sort of Bay Area capital region, as well as Pasadena and Westlake Village. And if you saw this and you went, wow, I need help, right? Or if you're thinking, I need to talk to somebody, go ahead and give us a call. You can give us a call, but here's what you should expect when you do make a call. You're not going to speak with the lawyer, right? It's not the FBI where they answer and it's an FBI agent. You will be connected with a client specialist, not one of our lawyers. Do let us know if you want to update or create an estate plan. Also, let us know if somebody's died. That's kind of the fork in the road. If someone's passed or become incapacitated, that's a little bit of the fork in the road into which department it goes into. In our firm, we have a lot of lawyers who focus on estate planning and a lot of lawyers who focus on trust administration. And so there's a little bit of a divergence there. And tell us your estate and tax planning goals. I want to save income tax. I want to, save on death tax, whatever your goals are. And then don't ask for pricing. Only attorneys can quote fees, and don't ask for legal advice because only attorneys can give legal advice. And the goal of the call is to set an appointment with an attorney in the firm. And if you're watching this on YouTube, go ahead and subscribe to our channel, click the little bell, and that will alert you when we post new content, which we do quite a bit. By the way, keep watching because we have another video that's going to get started right now.